Good day, and welcome to Epstein Becker Green's webinar, Privacy and Security Crash Course Recap. Your questions get answered. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You're welcome to submit questions directly to the presenter following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to feature a fantastic speaker today. Patricia Wagner is a member of the firm in the Healthcare and Life Sciences and Litigation Practices in the Washington, D.C. office of Epstein Becker Green. At this time, I'd like to turn the webinar over to Patricia.
Thank you, Whitney, and thank you all for joining us today for the last part of our crash course series on privacy and security. I want to go through some of the questions that we had, and I bucketed them into 5 subject areas, which are listed here: upstream compliance, downstream monitoring, risk assessment obligations, use of cameras in facilities, and then handling breaches when the breach is by the third-party administrator. So let's go ahead and get started. The upstream compliance. This question came in, and it's a question we actually get quite a bit, which is, as a business associate, what is our compliance obligation upstream? And the example given, which again we see all the time, is the business associate uses encrypted email to communicate with the facility or the provider or the health plan, but the covered entity, hospital, physician, health plan, does not reciprocate. And so the hospital or physician group is sending unencrypted email to the business associate. So if you're a business associate and you see that happen, I would recommend a couple of considerations. First of all, let's remember the privacy and security rules. They are intended, certainly on the security side, to have requirements that meet the needs of the organization or the size and scope of the organization. So as of yet, encryption is not required for emails. It is certainly best practices, and it is highly recommended. And in fact, the FTC came out with guidance today for security and business operations, kicking off their Start with Security campaign, and the guidance document they provided indicated that for sensitive communications, those communications should be occurring through a secured manner. So it definitely is good business plan, certainly what we would recommend as to be part of the privacy policies and procedures of an organization, but not yet mandated. So if it's not mandated, then again, as a business associate, what is it you can do? Well, you could look at the business associate agreement provisions to see whether there are any requirements placed on the covered entity in that agreement. Usually those are very heavily laden with business associate obligations, but once in a while there'll be covered entity obligations like sending information through a secure means. We sometimes also see those obligations in the underlying agreement, that the covered entity has a responsibility to send information through secure transmission. The next question, assuming that that provision exists, well then what do you do about it? Usually in the business world, nobody is going to want to terminate an agreement unless the risk is tremendously high for failure to comply with a provision like that. But it might be worthwhile to look at because it could give you an indication of what the covered entity thinks it will be doing operationally. And that leads me to my last point, which is really one of just good corporate citizenship. We see this a lot. Covered entities and business associates, we're all really trying to work in the same direction. A lot of times the covered entity actually does have policies and procedures requiring the use of encrypted or other secured transmission methodologies. And the privacy officer or the compliance officer of that organization has no idea that people are ignoring that requirement. So sometimes the best recourse is just a good conversation with the right person. The key, of course, is you have to find the right person, but sometimes that helps resolve the issue. Now, the flip side of upstream compliance is downstream monitoring, which is how tightly do we have to monitor subcontractors. And Subcontractors could be the business associate of the covered entity, or if you're a business associate, it could be your subcontractors. So as we all know, there are privacy rule requirements. Business associates have to report all security breaches, have to report all security incidents, and they have to report any use or disclosure contrary to the uses and disclosures allowed under the business associate agreement. Now, I'm going to use security incidents as a great example of this because, as we all know, every system gets pinged probably thousands of times a day, which are, because of the way the security rule defines a security incident, a security incident. But getting a report of every ping on the system is not very productive, right? It would be, first of all, too voluminous to do anything about, and secondly, it would assume people really could be able to capture all of that information. So we want to think about when we're monitoring our subcontractors or business associates, I always think it's better to start from let's think about the vendors we're worried about. First of all, how much PHI does a vendor have? Is it a little? Is it a lot? What kind of PHI is it? Is it sensitive information? Is it pretty generic information? What kind of reports would be helpful? If reporting every single security incident on a daily basis is not helpful, think about what reports would be helpful. Is it helpful to have an immediate notification if there's a security incident that appears to be problematic? Or would it be helpful to have quarterly reports that the business associate can give to the covered entity talking about issues that they found and resolved? Maybe it's none of that. If you have a comfort level with the vendor, you might feel comfortable that the business associate is doing that all on their own. You know, there are very sophisticated business associates out there who have privacy and security programs that are phenomenal and are tracking incidents and issues and addressing them. And then you may have vendors that you're a little unsure of, that maybe don't have a lot of information, but that you were a little concerned when you signed them up. And so those may be the vendors that you want to focus on and try to get your arms around what is going on a daily basis, and be a little more closely watch them a little more closely. Sorry about that. Next question is talking about risk assessments, and I start off with who is required to perform a risk assessment. We all know it's all covered entities and business associates, but the follow-up question to that is, what about a fully insured group health plan? And this was a great question because everybody forgets about the fully insured group health plans. The privacy rule has a carve-out for fully insured health plans. They don't have to meet all of the requirements of the privacy rule because they only get aggregate information and enrollment and disenrollment. The security rule didn't provide that same carve-out. So even fully insured group health plans need to do a risk assessment, but your advantage is you have very limited PHI. You only have aggregate information and enrollment and disenrollment information, and once in a while you may have beneficiary information if you have, through the use of an authorization, been helping a beneficiary with benefit issues. But, you know, that's the good news. The bad news is we can't forget about our FSAs and maybe the EAPs, which again are probably managed by a third-party administrator, but they might provide even a fully insured plan with more PHI than originally thought. The next series of questions related to the use of cameras, and this again is one we're getting more and more frequently. What are the limitations and barriers of using cameras in order to improve healthcare workers' safety and productivity? And that assumes the use by a facility, but we're also seeing more and more use by outsiders. And when I say outsiders here, I don't mean people coming in with their cell phones recording. I mean law enforcement coming in with wearing body cameras. So what kind of considerations do we need to have in place when we're doing this? First of all, we want to think about who's being filmed. Is it only going to be the patient being treated? Is it going to be visitors coming into the facility? Is it going to be, you know, if you're the facility, you can control who is being filmed. If the camera is on an officer escorting somebody in custody, then the question is, well, who else would that body camera be filming? Other patients, other visitors, including the patient in custody. Second to be thinking about is what happens to those tapes and films. You know, if you're the facility, you can control what happens to them. You can make sure they're secured. You can make sure that people who shouldn't have access to them don't. But when you're dealing with law enforcement who may be coming in with body cameras, some of those videos may become part of a public record. And then you have to think about not only, again, is the person in custody being filmed, but the employees who were assisting that person and other patients and visitors who were in the facility at the time. And then think about what is being filmed. There are certain state laws and federal labor laws that would prohibit filming in certain places, for example, the employee lounge or maybe employee restroom, or obviously employee restrooms. And there may be other prohibitions, for example, prohibition on filming union activities. All of those need to be taken into consideration. And when you're thinking about camera placement, again, focusing on safety, but then you have to think about what else might be occurring in the place where you're setting the camera. So I wish I could tell you there was a short and easy response for how to consider what parameters for the use of cameras, but unfortunately, it's pretty complex, and it requires consideration of state and federal issues, as well as, in some cases, just common sense and employee morale issues. And the final question, which we've gotten, is what happens, as you can imagine, this maybe is a popular one right now, what happens if our TPA has a breach of unsecured PHI? Is it our responsibility to report the breach? The answer is yes. It is still the covered entity's responsibility to report the breach, but covered entities can delegate that requirement to third-party administrators. In fact, if you go to OCR's form for reporting breaches, they've changed the form now so that the entity reporting the breach can select if they are a covered entity. They can select if they're a business associate, or if they are, the third choice is a covered entity reporting on behalf of a business associate. So you might want to delegate the reporting to the third-party administrator. Just remember, when you do that, you need to be mindful of how much control you're going to have over the communication. And that's thinking about that communication not just to the members who are going to get the letter and the notice of the breach, but also the communication to OCR. I've been involved in instances where the business associate may want to frame the incident to OCR in a manner that is not quite how the covered entity would like it to be framed, and vice versa, obviously. So when you delegate, sometimes delegation is good because it puts the entity responsible on the front lines, but you sometimes lose a little bit of control when you do that. That's the last of our questions. I want to thank everybody for participating, for hanging in there through this crash course series, and with that, I will turn it back over to Whitney.
Thank you for joining us. If you have any questions, please feel free to contact today's speaker, Patricia Wagner, at pwagner@ebglaw.com or via phone. This concludes today's webinar, and approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you.